There we go. All right, so what we're going to talk about today is risk management regarding the buyer representation. When Sean and I met yesterday, he said, so this is just for buyers. I said, this is just for buyers. Why do you think that is? Who do we have to spend the most amount of time training now that things have changed? Buyers or sellers? Buyers, right? Because you've always talked to sellers about this kind of stuff. You just never have talked to buyers about it. So that's why we're doing risk management for buyer contracts and representation. So, oops, I didn't want that. So look at your outline, and the PowerPoint's minimal. It's just little things that I added in there. Sean and I are just going to be doing discussions. And you have with you, of course, the sheet that says write down your questions. So we're doing that the same. And the reason we are is because we're filming this. So you can't ask questions during the class. Got it? So write down your questions, and then we'll pick them up, and then Sean and I'll take turns answering them towards the end of the class. Okay? All right, good. So first of all, the benefits and liabilities of buyer representation. A long time ago in a country far away, I wrote a book on buyer representation. I looked at it the other day. It was 1997. And so this is one of the things that was in the book, and I thought this is something we really, really, really need to talk about. Because a lot of people think that buyer representation is just easy. Do you think so far it's easy?
No.
Huh? How's it going? Has anybody gotten an agreement signed?
Yes.
Well, there, yay, right? So one of the things I think that we need to talk about is it's not all roses, right? Because there are some liabilities, and there are certainly some benefits. So look in your handouts, you've got a sheet that says benefits and liabilities. One of the things that I think is nice about it is that for you get the benefit, for the buyer, gets the benefit of having a commitment from an agent. Now, on the other hand, it could be that that agent, oops, just a minute. Battery went out.
Yeah. I think the battery on both of these is pretty low.
So that agent might not be the right agent for you. That ever occur to you? Did it occur to you that maybe that buyer isn't the right buyer for you? Right? How many of you have ever started working with a buyer and gone, and you've been glad you don't have a written agreement with them? We're going to have to get new.
Yes.
Tiana, these mics are toast.
Both of them.
I'll use this. So for right now, the benefit is that the commitment of your agent is nice for the buyer. A liability is that you might owe the buyer a fee. Another benefit is the ability to receive advice and counsel. Now, if down here we are transaction brokers, and we can give advice and we can give counsel, but we can get more in-depth advice and counsel if we're single agents. Contacting the wrong agent would be a liability. We can advocate for you if we were a single agent. In transaction brokerage, you cannot advocate. You can help them come up with prices, you can help them negotiate, but you can't advocate. That is just a no in transaction brokerage. And then just to think about, maybe sometimes, and you're going to experience this, you could have an uncooperative seller's agent that you're working with on the other side. And then the buyer can request to be anonymous if they want to, and that's one of the benefits in working with a buyer agent, is that they can make sure that that happens, a buyer broker. Now, for the seller, why is there less liability if the buyer is represented by their own representative? Why would that be the case? If you are working, and don't take this wrong, if you are working with your realtor that you have your property listed with, you take on the liability for anything that they do wrong, that you knew about and didn't correct. So if the buyer is working with their own representative, then that representative has some of the liability. Hopefully, you've got a more qualified buyer when they're working with somebody that signed an agreement with them. Wouldn't you want that buyer to be, your buyer to be really, really, really well qualified before you take them out and show them around? As opposed to somebody who just walks in. Now, for the seller, the stronger negotiations are made by the buyer and their agent. That's a little bit of a detriment for the seller. Lack of knowledge about the buyer. The other day in class, I can't remember who, let's see her, looking around to see if she's here. The other day in class, somebody walked up to me and said, my seller wants to know if the buyer is a pain in the wazoo. And she said, well, it's being represented by another agent. And he said, find out. He said, I'm going through a terrible time at my work right now. I've got the stress of moving, and the one thing I don't need is 30 days of a pain. So she went and asked the buyer's rep, and the buyer's rep said, it's kind of a pain. And so she said, can I go tell the seller that? And he said, sure. And he went, well, then I'm not going to look at offers from them. And she said, that might not be a good move. And he said, truly, if their agent says he's a pain, he must be a pain, right? So they will ask you questions about the buyer. And the nice thing about the seller, for the seller, is that the buyer is represented, but it also can be a liability. Now, for you, the buyer's agent, the benefit is you've got the loyalty of the buyer, which you haven't had, have you? No. And we have better use of our time. The other day, somebody went and drove out all the way out to Cape Coral to show a house, and then pulled out the form, and he wouldn't sign it. So better use of time. Less conflicts of interest, and I'm guaranteed compensation if I have a buyer rep agreement that says compensation. One of the things that we talk about is that there's increased satisfaction for all parties, because you know you're working together, and there's residual advantage to it. Now, one of the things that could be a liability for you is having an unethical buyer who asks you to do things that are unethical, which you know you can't do. You have always been accustomed to looking up in the MLS and seeing the compensation being offered. It's not that way, and so there could be adverse compensation situations that you need to deal with. We don't have dual agency, so that's not a problem. And right now, are you feeling kind of any mistrust in the industry? Right? I was out with one of my customers the other day, and he said, start talking to me about this. And I was in a restaurant, crowded restaurant. He said, I can't. He said, why not? He said, it's just not a discussion you can have in an open environment like this. So he's an older gentleman, and he's trying to sell his condo in New York. And he said, well, I'm just going to tell you right now, if I've got to pay your fee, I'm going to have to go and renegotiate all my savings, because it's fine, don't worry about it. And then the liability of this there. Now, this is the one that Sean and I talked about yesterday a lot, is that what we feel for the real estate community right now, it's a level playing field. Do you think that that's true? It's becoming more level? And then we're trying to increase professionalism. And change is difficult, and there's a lot of mistrust due to the unfamiliarity of doing any of this. And then we're going to talk about the abuses of representation and the lack of education, which is why we've put together this whole series of education, which I'm so glad so many of you are taking advantage of all of them. So, benefits, liabilities, they come around. Now let's talk about some of the misperceptions that we have to deal with. One of the misperceptions and the misuses by the buyer is that they assume that you can do absolutely everything for them. And that's not necessarily true. We've been talking about the buyer could ask you to do something that's unethical, and you can't do that. And they are assuming that the buyer broker can help steal the property because you're being represented. Now, how much can I get that for? It depends upon the situation. You don't know that. And we were talking about the fact that the wind changes. Sellers can change their mind from one day to the next, right? All right, so misconceptions and misuses by the seller's agent. Refusing to work with a buyer's agent. Have any of you come across that?
Yes.
Yes? Already started? Refusing to compensate the buyer's agent or offering adverse splits. We're going to talk about that today. refusing to disclose their advantages in reduction of liability to the sellers, and then refusing to allow the buyer's representative to present the offer. So Sean is our MLS guy too. Just know that if a buyer really wants you to go present their offer to the seller and to the listing brokerage, it's an MLS rule 2.0, 2.4, 3.4. It's in the MLS rules and regulations that a buyer's representative can ask for permission to go present their offer to the seller and the listing agent. And Sean said, do people ever do that? How many from up north have done that for years? Everybody, Minnesota. Yeah, we have Minnesota and South Dakota, Iowa, we have done that for years and years and years. It works out pretty good, doesn't it? Except in the middle of a blizzard when people are all lined up out in front of the house, right? Multiple offers. So then let's talk a little bit about the misperceptions and misuses of a seller's agent, or I'm sorry, of the buyer's agent. Now, there are a couple big ones here. Failure to disclose the relationship to all parties. If your relationship changes from transaction brokerage to single agency, you have to remember to disclose that and give the form. And failure to address the compensation issue up front. I don't know how they can avoid that now that we've got it right up front, right?
No, look, we all know that that is now something that must be set out in writing, in advance. It must be ascertainable. It cannot be so you are having those conversations with your buyers up front with respect to compensation. If, whatever arrangement that you were going to have with your buyer, you're having those conversations up front. And so that certainly no longer is that a problem, because you must have that to be compliant under MLS rules, to have that in writing, in advance, whatever you're going to agree with your buyer with respect to it. So that will hopefully be solved now.
I think bullet 3 is one that we have been dealing with a lot, trying to circumvent the Board of Realtors and the MLS rules. What do you think?
Okay. If anybody is listening to any of my presentations, is please stop spending any mental energy trying to go around the rules or just stop it. It's not worth your time. Pick up the phone, have a conversation, spend your time on being productive instead of trying to come up with creative ways where you can go back to maybe the way things were done in the past. That's just not an option anymore, and so it's really not worth even considering for anybody who's out there thinking of frankly, and I apologize, but the ridiculous things that I've heard that people have done or are trying to do. I mean, from an MLS perspective, compensation is no longer in the MLS, so that better be agreed to and in writing between you and your buyer ahead of time. So it's just not even worth spending any time trying to go around those MLS rules with respect to, buyer broker compensation. So.
Not to mention the fines.
Well, right. I mean, look, it's the failure to have a buyer representation agreement that complies with the settlement is a $500 fine. A listing agent that is improperly using the MLS to display compensation in any way is a first fine of $1,000. And the second one, I believe it's $2,500, and your broker is going to come in as well. And the third one is a 60-day suspension in the MLS. So, I mean, So it is certainly not worth it. You need to make sure for this presentation, what we're talking about though is having a buyer rep agreement that complies with the terms of the settlement, right? So we need to know what needs to be in our buyer rep agreement to make sure that it complies. NAR has promulgated a form for a buyer broker exclusive agreement, and then there's also going to be hopefully some other forms as well coming for property specific buyer broker. So it's not worth anybody's time trying to circumvent any rules, settlement, or otherwise. This is the world we live in now.
And we're going to talk about those in a minute. Now, the next one, Sean's an attorney, so I asked him yesterday, what do you think? Signing the buyer agency contract for an unreasonable period of time. So anybody who thinks they're going to sign a buyer up for a year, what do you think that's going to happen? What do you think is going to happen?
Well, look, as an attorney, you're always...
Not our attorney, but as an attorney.
As an attorney, not our attorney, not NAR's attorney. Obviously, it always depends on the facts and the circumstances of that relationship, right? But, I mean, to me, if somebody came to me and says, well, I met this agent for the first time yesterday going to show a property, and I signed an exclusive agreement for a year with respect to that, I think you're probably going to have some real problems, whether that is from a legal perspective, or whether it's just simply from an unhappy buyer perspective that you're like, well, I've locked that person in for a year now with respect to that, and I just met them. Probably not a great idea. And we're talking risk management. We're not talking ultimate legal responsibility, and there's all sorts of factors that go into something like whether an agreement is unconscionable or is it enforceable. But you probably don't want to be, since we're talking about it, walking on, the first time you meet somebody, you've never met them in person before, and you're getting them to sign a year buyer broker exclusive agreement. I think that might present some problems for everybody. So.
Yep, don't do it. In fact, we had a case up north where the guy continually signed them for a year, and the buyers reported them to the real estate commission. And the real estate commission said that is taking unfair advantage, so don't think about doing it.
But just to be clear, I mean, look, each brokerage is going to have their own buyer broker agreement. They're going to have their own policies with respect to whatever this looks like. And so that's where you look to first, and whatever your brokers are indicating with respect to buyer broker agreements. But I think you really have to keep in mind, locking somebody up that you've just met to a 1-year buyer broker exclusive agreement, you probably need to just think carefully about that. I'm not saying that it can't be done, and I'm not saying that it's not allowed, any of those pieces, but just think very carefully about that. And there are all sorts of options, and there are all sorts of forms, and we'll talk about those as well.
Yep, we will. And then demanding an excessive fee. I haven't seen a lot of that, but I'm sure it's happened over the years. So then, how about the misperceptions and the misuses by the industry right now? So we've talked a lot about the fact, is there going to be someone who's going to limit the availability of properties to the buyer's reps? I'm hoping not. But back in the day when this whole started, before everybody got accustomed to buyer representation, there were brokerage companies who said, we're not going to compensate any buyer's agents, so it's not going to happen. I don't think that's going to happen here, but it could in other parts of the country. Lack of adequate and responsible education. We are trying to give you as much education as possible. I look out across the room and I see all of our students that keep coming to all these classes. Are you getting the education you want? Are you getting it? Okay. So what I'm going to have you do on your question sheet is we have an opportunity coming up where we can get a couple of other topics covered. What topics haven't we covered that you would be interested in knowing more about? So think about putting that down. Misconceptions out in the public. What's not helping, the press isn't helping by posting these stories on the TV that are completely incorrect. So what we've done here at NAR is we have, thanks to PJ Smith, our president, she's put together a whole media group, and we are hopefully going to get as many of those problems taken care of, and we've got a real aggressive campaign going out there. And then aggressive tactics by attorneys. You wouldn't do that, would you, Sean?
Of course not.
Sam, how about you? No, okay. Lack of understanding by the regulatory bodies making laws and rules. So let's just kind of talk about that. And this, what happened here is not a law, right? I've heard people say, we've had this law change. It's not a law. It's rules. Want to explain it so they understand? They can explain it.
Well, the distinction, obviously, it's not a statutory change. There's no federal law, but there is going to be an actual, enforceable settlement agreement that our MLS has opted into that has certain requirements that I'm sure everybody here is super aware of when it comes to compensation, buyer broker agreements, and all the other requirements that you're needed to fulfill. So there is a legal and binding settlement agreement, and while it may not be a change to the statute, anybody who is a member of NAR and a member of the National Association of Realtors has to abide by those terms and conditions of the settlement with respect to it. So while the actual, say, statutes may not have changed, the practices that you're required to follow have changed as part of NAR, as part of MLS, as part of the National Association of Realtors. So.
And it affects only us as realtors. So there has been talk about the Real Estate Commission going to the legislature this year and asking them to make that a state law, that all licensees need to have the buyer rep agreement. So people said, well, what's the difference? The people who are realtors belong to the National Association, the Florida Association, and NAR. There are lots and lots of licensees out there in this state that are not Realtor members. They just have a real estate license and operate on their own. So be sure you talk about the benefits of being a Realtor, but then understand that if somebody says, well, I just had somebody contact me and they don't have to use a buyer rep agreement, ask if they're a Realtor, because if they're not a Realtor, they don't. Okay? All right, so those are some of the things that we just want you to kind of think about before we get started, and we'll kind of build it in here. So we were having a discussion yesterday about the duties that we owe to our buyers and stuff. And so in your packet, I put in the old form that you used to use prior to 2008. Now, I didn't come down here until 13. But I'm telling you what, when I found out in this state, you never even had to make a disclosure of who you were and the duties that you owe to somebody, I about fell off my chair. And I said, well, how can that possibly be? And he said, they just didn't need it anymore. Well, if you didn't show this to any buyers that you're working with, they don't know what to expect from you, do you? How many of you still give this form out when you first start working with? Look at that. That's great. That you still give it out because it's so important. Now, the problem is it lists all the duties here, and that was pretty good. But now they're listed somewhere else. Now, where are they?
Well, I assume you're referring to our buyer-broker
Yeah.
agreement, where now it actually states that everybody is going to have a buyer-broker agreement, and then within that buyer-broker agreement, it says, what am I going to do as your buyer-broker, and what are you going to do, Mr. Buyer, with respect to it? And one of the benefits to that, as we talked about, is the fact that it clearly lays out expectations for all the parties. These are the things that I'm going to do. For example, in our new not new, but the buyer-broker exclusive agreement indicates that you're going to monitor contract deadlines and ensure compliance. Well, so that means now that you in fact have a signed contract with somebody if you have this buyer-broker agreement, and you have the obligation to make sure that you are monitoring those contract deadlines and ensuring, compliance. I'm not saying that you weren't doing that before, because I'm sure all of the agents in here were, doing a really good job making sure they were hitting their inspection timeframes and their financing contingencies, all the really important deadlines. But now it's in writing, so nobody can say, well, I didn't know I was required to, to worry about those types of contract deadlines. I didn't think I was doing that, for example. Well, now it's clearly there in writing. And I just want to take briefly, when I think as an attorney of risk management, the example I like to use where people will ask me, they'll say, well, they'll call me up. I get a lot of listing agents, they'll call me up and they say, Sean, there's something going on with this property, and then they'll give me an explanation about it, and they'll say, do I need to disclose that to the buyer, right? That's the question that they'll ask me, and I realize we're a buyer rep. And my answer to them is, if you have to call your attorney and ask them whether you need to disclose that to the buyer, you probably should just disclose that to the buyer. Because the downside is so great for your seller and for you for failure to disclose, and the upside, it is very little. That's what I call the sort of the topic of risk management, right? Can we look at the exact piece of the statute and we can parse out whether or not you would have to disclose that, for example. And there may be instances where we need to do that. But in general, if you have to ask me, you have to call me, then you probably need to disclose that. And I use that same example when it comes to risk management, because we always want to make sure that we're doing the best thing. It may be, there's the bare minimum. The bare minimum is we're following the law, we're following the pieces, we're following what we need to do, right? That's the bare minimum. And then there's a whole other pieces that I get questions about on a daily basis. Do you think this is a good idea? Do you think this is a good idea? How should I do this? And we always have to look at the upsides and the downsides with respect to that. And that's part of what risk management is about. And it's part of what risk management is also about for buyers now. Because now you're going to have these buyer-broker agreements, and you're going to have very clearly defined roles in your buyer-broker agreements. And you have certain responsibilities under that buyer-broker agreement. And so you just need to be thinking carefully about that from a risk management perspective, because I think that now is something that buyer brokers and buyer agents are really going to have to make sure that they're contemplating. So I know that wasn't exactly where you're going with it, but I just, since we're talking about this topic, I really do think risk management, what are good practices? They may be totally allowed under the law, but they may not be a good practice. They may be risky. They may be the type of thing where you're going to have a disagreement with your buyer over. And one of the really core principles in the law, and what we love about contracts, is we like to set expectations up front, right? Because if everybody knows what those expectations are, it's really hard later on to come back and say, oh, you know, I didn't know you were going to charge me this, or I didn't know you were going to do that, because we all had that conversation up front. And so we're transparent, and that's what we as lawyers love. That's sometimes why our contracts are super long. But on the other hand, we can just say it's there, it's right there in writing. That's what we said we were going to do, and that's what we did. So one of the best ways to mitigate your risk is to have clear expectations and conversations up front with everybody. And don't play the gotcha game at the end. Well, actually, if you look there on small print on line number 7, that's never going to go well, right? And so, anyway, that's my intro on risk management from a legal perspective, from my perspective.
And when we get to the buyer rep agreement, if you want to, compare the disclosure versus what's in the buyer rep agreement. In the buyer rep agreement, it's much more firm on what your responsibilities are, and you're going to need to really pay attention to that and know what it says. So one of the other things Sean and I talked about yesterday was we have people moving here from all over the country. And how many of you are from New York?
Don't be shy.
Hold it.
Don't be shy. It's okay.
One person.
Won't hold it
two,
against you.
2. So what we hear all the time is that people from New York go, well, that's not the way we do it here in New York. We always have the attorney draw it, right? Well, we don't do that here. So we talked about the fact that one of the things you probably need to do is spend a lot of time talking about the process here. What is the home buying process? So I had this tucked away. This is just an example of what you can create, okay? So create something that you can give to the buyers and say, here's our process. This is how it works down here. For example, we use title companies. Back up in Iowa, we've got a really strong lobbying organization, and we use just the abstract of title, and the attorneys close the deal with the bank. We don't have title insurance. So every single state has different nuances in what they're accustomed to doing. So this is just a sample, but put together one that you can show the buyer what they're going to be doing throughout the transaction and what you're going to be doing throughout the transaction.
Yeah, and I would just say my favorite call is I'll get a call and they'll say, well, I'm a lawyer from New York, and I'll say, oh, okay, here we go. Love you lawyers from New York, but you have very different experiences than the rest of us down here. And here's where it really matters for you guys as buyer agents especially, because I'll get a call from a client and they'll say, I signed this contract this weekend, I want you to go back and negotiate this contract for me. And I'll go, wait a minute, you've signed a contract over the weekend. And they say, well, up in New York, we do a pre-contract, and then the lawyers handle the contract, and then we then we have inspections, and then we go to contract. And I go, whoa, that's not how it's done here, unfortunately. And most of the time it's okay. But sometimes, it can lead to that expectations where if the buyer's agent had set the expectation with that client that we're going to be under contract, be super sure that you want to buy this property, for example, if it's a regular contract, and then we have inspections that you're not going to be able to get out of it if you don't like what those inspections say. Or you say, well, if you're a little nervous, we have an as-is contract, we can do our inspections, we have X amount of days under the as-is contract. So that's an example, I think what Marcy's talking about, where we're setting our expectations, we're understanding what this transaction looks like, and so there's no disappointed folks at some point, because that's not the type of relationship you want with a client. And they do it very differently in other states. I don't know if it's Connecticut but I get these people all the time, they're like, that's not how we do it. I was like, I don't know what to tell you.
But that's not how we do it.
I understand that. We can draft a custom contract from, scratch if that's what you really want, but it's going to cost thousands and thousands of dollars. And they go, oh, okay, we're fine with the pre-printed contract. So anyway, but yeah, setting those expectations, understanding the process. I mean, whether or not you have a diagram or whether you can just explain it in a way because you've done it, I think that's great. Yeah.
And one of the things that a lot of people don't understand are all of our timetables for HOA documents and that type of thing. And I had a buyer say, well, it's okay, I don't need to read them. Oh, but you're going to read them, trust me. And he was a realtor in Iowa. And I said, no, you're going to read them. He was in a condominium building. And I sat him down and almost like read them to him because he needed to know those. And so how many days do I need to know that? What do I need to know, right? And those are the timetables that you need to be sure that you give them.
And if they say, well, Marcy, I'm not going to read them, I don't care. Well, then I would put that in writing to them, right?
Okay.
Be like, hey, I sent these to you and I encourage you to read them, and you indicated you didn't want to do so. I was telling Marcy, a lot of times as a lawyer, we will have verbal conversations with people, and then we'll follow that up with an email and say, as we discussed earlier, we've provided you a copy of the documents, and you've indicated, you're good with it, or what, just so that for your file it's clear, because then when that person later comes back and says, wait a minute, I have a dog that's 30 pounds and they only allow dogs up to 25 pounds. You didn't tell me that that was a problem. Well, wait a minute, we had this conversation, I provided them to you. I'm not a lawyer, I can't interpret condo documents, here they are. So that's the type of a risk management, once again, that I think Marcy's talking about, where making sure that if they aren't gonna do it, put it in writing. Please, I know it's not this topic, but if they're not gonna get an inspection, please put that in writing, that you encourage them, to get an inspection and they said no, or that we offered them a mold or a radon. Occasionally I get people that say, I didn't even know there was a mold or radon test, I want one. Well, at that point there was nothing we could do. So just make sure you're having those conversations and disclosing, and then documenting your file as necessary. And I know that sounds like a lawyerly thing, and it is, but it's also part of risk management to make sure that if there's ever a question later on, you've had that conversation and you understand it.
Yep, perfect. All right, Sean, you're next. So there are various forms that we can be using, and you've got a bunch of them in your packet. That one is the pre-touring one, right? So Florida Realtors has several forms that you can go and find on Form Simplicity, or you can find them on Florida Realtors' website. And we just want you to understand that there are lots of forms out there that you could be using, like this is a compensation agreement. And Sean, you covered, there have to be 4 things, no matter what agreement you use, right?
Yeah, to be clear, Florida Realtors has their forms. They have a pre-touring agreement, they have a buyer property-specific agreement, they have an
Showing
exclusive,
agreement.
they have a showing agreement. You can use any of those forms so long as they're compliant with the terms of the settlement. NAR has a buyer-broker exclusive agreement, and then, like I said, you will see, I hope, soon, a property-specific agreement. And your brokerages may have their own agreements. I know a number of large brokerages here in town have their own buyer-broker agreements, and that's totally fine so long as they comply with the terms of the settlement. And as Marcy's indicated nicely here for everybody to see, conspicuous disclosure and how it's determined. The amount must be firm, no range, a prohibition of receiving compensation that exceeds the agreement, and obviously the required disclosure that it is fully negotiable. But it's really important that, I know that one of the issues that people have is the range question. And I know I've heard of some buyer broker agreements out there that have sort of these conditional statements that if, compensation isn't being offered, then no compensation will be. That is under the terms of the settlement. That's not allowable. You have to have a written agreement up front that is ascertainable on its face. It cannot be sort of conditional on these other pieces. And we spoke to NAR's attorney and put that question to him directly about that type of provision, and the answer was no. And that's consistent with our understanding and thoughts with respect to the settlement agreement. So like I said, it's totally fine for your agreements to come from your brokerage, and I encourage you to speak to your broker and follow whatever their policies and procedures are with respect to buyer broker agreements. If they don't have anything, obviously Florida Realtors has them, and then NAR has them. You will see agreements called touring agreements. Just make sure that they comply with the settlement, that it's conspicuous, that it's not a range. And then the other really hard one for people is that a prohibition of receiving compensation that exceeds the agreement. So if you have a written buyer broker agreement with your client, and it agrees to pay them X, but the listing agent may be offering a greater amount, let's call it Y, you are unable to keep the difference between X and Y.
Unless?
Look, as a preliminary matter, you are not entitled to receive that difference. Now, can the buyer broker agreements be amended? Sure, they can be amended, and those pieces can be taken care of. But I want to be clear, though. Remember, an amendment to your buyer broker agreement requires the consent of both parties. So your buyer is going to have to agree what happens to the difference between X and Y. And there may be a great reason why you could use that as a negotiating tool in the offer, if you know maybe that the compensation being offered is greater. So you have a lot of options as a buyer rep, but you do have to at least have a minimum agreement with respect to these. So I can't, we're not providing any guidance to people as to which agreement they should use, because that's not, our role. We are going to have those forms. We do have currently a form that's compliant, and then Florida Realtors has their own forms, and each brokerage may have their own form. But you just make sure that it meets these 4 pieces before you go ahead and do it.
So why don't you go into the buyer brokerage agreement? Since
Okay.
we've got the expert here, you want to take advantage of it, right? So not that we're going to go through the whole thing, but there are some things I think that you believe need to really be pointed out. First paragraph, of course, is all those duties that they owe.
Okay, I think you're probably referring to the buyer broker agreement exclusive that NAR has, and that's in your packet. I'm not sure what page it is, so if you all want to go to that. There's a couple of videos, by the way, on NAR.com that go through some of these, including this buyer broker agreement. So if you have a question that we don't go over it in as much detail today as maybe you'd like it to be gone over, there are videos on NAR.com from a July 31st webinar that was done that has an extreme detail with respect to the buyer broker exclusive agreement. Does everybody have the buyer broker exclusive agreement in front of them? Because I don't think we're going to be able to put it up on the board. So, okay, great. All right. Okay. So first of all, we talked about this earlier. On the first paragraph, it says, here's the broker's role. And it lists out A through E of the duties that the broker has to the buyer. Consult to discuss property requirements, assist in obtaining information related to the property, best efforts to identify and locate, and tour. So this word was changed. Now we use the word tour. Assist the buyer in presenting and negotiating a contract, and then monitor contract and closing deadlines. That's the one I was referring to earlier. So there's a specific obligation on the part of the buyer broker to monitor the contract deadlines under this agreement. You could have a different agreement that says something different, but at least under this agreement, you're agreeing to monitor those contract deadlines. And of course, me as the attorney, I worry about, because obviously that matters, right? We have to calculate effective date. We have to calculate inspection timeframes. We have to calculate appraisals. We have to calculate all those, are things that we really want to make sure that we're comfortable with. And so those are the expectations, at least under this buyer broker agreement, that the services you have agreed to provide for the client. And then number 2, I know Marcy's favorite. She's way better at talking about transactions, single agent, no brokerage piece there. But there, under number 2, you can indicate in what capacity are you working for them. Are you working as a transaction? Are you working as a single agent? Or do you have no brokerage relationship? So for example, I do have very limited duties and no brokerage relationship, and Marcy can speak to that briefly, because I do get questions about no brokerage relationship. What does that mean, Marcy?
That means you only get 3 duties, 3 little duties, and that I don't represent you at all. And we would use a no brokerage relationship when we're working with a for sale by owner, for example. We don't have any brokerage relationship with that for sale by owner. We were talking about the fact that if you're a single agent, and we'll talk about, just let me tell you that if you think you can do a single agent representation, you need to talk to your broker, because it's part of the broker policies. And if they don't allow single agency, you're going to need to get permission from them to be a single agent, because it puts the company in jeopardy. So the transaction broker is where you need to be by law, because you default to transaction brokerage. But if there's a situation where you are, one of the things we're going to talk about is open houses, but this is just a good example. I'm doing an open house for a friend who works for a different company. So I don't represent their seller, do I? Nope, I don't. So when I have that open house, I need to put a no brokerage relationship sign up. I have no brokerage relationship with that seller, and the buyer walking through the door, I don't currently have a no brokerage relationship with either. And a long time ago in Florida, that was just what they did in all their open houses. So you need to know who you are, and that's what you check. And I had so many people the other day say, well, my buyer wants single agency. I said, first of all, how did they know about it? How did they know? Well, they just know. Well, we haven't done any classes on single, well, we did one class on single agency. How did they know that? And they said they've been listening to the news. So if your brokerage will allow you to do single agency, you can talk about it. Otherwise, you're going to need to get permission from your broker, okay? All right, onward and upward.
Okay, yeah, I mean, single agency, that's another risk management topic, right? Because you're agreeing to take on greater duties, greater fiduciary role to your client, and that's what Marcy's talking about when she says your broker has greater potential liability, so that's the risk management. So if you're going to agree to take on single agency, well, you better know that you're taking on additional risk, and your broker better be okay with it, because they then potentially have greater liability with respect to the transaction. So under Florida law, as sounds like everybody here's been going to the class and following along with Marcy. I see everybody nodding their heads, which is great. But as everybody knows, transaction broker is the default unless you select otherwise. So here you can clarify your transaction, your brokerage relationship. I think that would be a great opportunity to give them the transaction broker disclosure, for example. If you would say, hey, okay, I'm going to be your transaction broker in this transaction. Here's the disclosure. Here's the duties. What does that mean? What is a transaction broker, right? This is a great conversation to have, great time to have that conversation with your buyer with respect to it. Number 3 indicates the buyer's role. What are they going to do? You're going to work exclusively with me and be available to evaluate and view properties. You're going to refer, just like on the listing agreement, you're going to refer all inquiries from any source to me. You're going to provide reliable information, including financial information necessary for the performance of this agreement. Provide to broker general information regarding location, price, amenities, and other information to help identify the properties, and all locations notify other brokers and third parties of the existence of this agreement and broker's exclusive relationship to buyer. Are you working with an agent? I am exclusively working with whomever that may be. That's important. So the buyer has an obligation under this to disclose that.
And that's important. You have to really go through that, right, Sean? And explain to the buyer what that means to them. Because it's exclusive. We're going to talk about exclusive versus non-exclusive in a little bit. But we've never said to a buyer before, you have these responsibilities. And they could be looking at you going, what you talking about? I never have had them before. So make sure you cover them.
So, yeah, term of agreement. So number 4 is term of agreement. Buyer engages and grants the broker the exclusive right and authority to negotiate and purchase. And then there's a time frame in there. It starts today and goes for, the default is 6 months. You can write in whatever time frame you and your broker think is appropriate for that, the termination date with respect to it. As Marcy and I indicated, each circumstance may be different. Think carefully about what that looks like. I've heard some people say, well, we could use this for a day, and yeah, I guess technically it could be a day. It could be a day agreement. I think maybe you might want to use a different agreement. If you wanted to just do a day, I think a day for an exclusive agreement. But on the other hand, that's up to you guys and your broker and their policies. The automatic time frame is 6 months, and it can be shorter and it can be longer with respect to it. And people often ask this question, and I see this get asked on listing agreements as well. Well, what happens if we enter into a contract, it's going to close in December, but our listing agreement, terminates in November? What happens then? Just like a listing agreement, this contract automatically is extended for the time frame of that contract. But just know that if something were to happen to that contract and that was to terminate, well, then this agreement is no longer in force. So there is that automatic provision where it extends from if you enter into a contract. But if that contract ends, then your termination, then your agreement doesn't continue at that point in time. And then let's say you have identified a property during the time of this agreement, and your agreement ends, and then later within a time frame, they purchase that property without using your services, you can indicate in here that if, for example, for the 90-day period after the termination of this agreement, if you were to purchase a property that we looked at, then you're going to owe me the compensation under this agreement. And so that's a term in here. It's under, there's no lines, but it's under paragraph 4. And the default is a 90-day period. So, if I go show you 123 Main Street, and then our agreement ends, and then within 90 days, you go ahead and purchase 123 Main Street, technically under this buyer broker agreement, you're going to be required to make payment under the terms of this compensation agreement. And of course, I'm sure there'll be some fun procuring cause potentially and other discussions that may happen. But as a technical legal matter, under this buyer broker agreement, that extends. Number 5, I'm probably not going to spend a lot of time on, only that's the broker compensation portion of it. Obviously, it's got the required disclosure that real estate broker and/or any brokerage compensation is not set by law and is fully negotiable. I think it's pretty self-explanatory here. You have the option for a percent of the purchase price and a dollar amount, a fee of a dollar amount, and then there's an optional box there, and that can be whatever you want. I jokingly consider this to be the horse provision. For example, if you were bartering your services for a horse, you could put that in there. I'm not saying your broker would allow such a thing, but whatever other agreement you have that may not be expressed in a percent or a dollar amount, that's fine. I remember as a young lawyer, I think I once did an exchange of services because the client didn't have money and he was a great contractor in town, and I did an exchange of services. So that's up to you and your broker and your policies. You are very flexible in your agreements with respect to this.
It could be retainer fee.
It could be a retainer fee. I mean, there's all sorts of options that maybe not are necessarily expressed in a percent or just a flat dollar arrangement. And so you can put that there, but be very careful because it once again must be ascertainable. It's not contingent. It's not if the listing agent is offering compensation, or it's none of those things. It needs to be an ascertainable amount. And so just be very clear about that. And then it also provides for, because we all have been in those circumstances where your client says, I'm going to purchase this year, maybe we'll just lease. Okay, well, we have a provision in here that says, what am I going to be paid if you lease? And that's what the and/or provision there is. Okay, we're going to flip over to page number 2, because the top of page number 2 is the most important section, I think, for you to understand and explain to your buyers. And I know Marcy didn't want me to go into all the detail, but I do need to go. All right, I do need to go into some of the detail, because this is a dense paragraph, right? This is the top of page 2 of the buyer broker compensation agreement. So, compensation that was agreed to shall be deemed to be earned on any property purchased or placed under contract, irrespective of whether the broker actually showed, located, introduced, or wrote any offer on a contract with respect to the property or properties under the terms of this agreement.
Huge.
So keep that in mind. That means that if you have a buyer-broker agreement, exclusive agreement, if you're using a different form, this may not apply, but under the NAR one, if during the term of this agreement, your client purchases a property, not using your services, and you never introduce that property to them, technically, they still owe compensation to you. That is the nature of an exclusive agreement, right? That's the difference. It's exclusive. If you buy anything during the term of our agreement, you're going to owe me the compensation that was agreed to in our buyer-broker agreement. That is the nature of exclusivity when we talk about an exclusive agreement. And that's something that people need to understand, right? Because if you're going to sign a buyer-broker exclusive agreement, that buyer better well understand that if they do go and they say, I met so-and-so at an open house and I bought a property through them, sorry, I appreciate your time. Well, there's actually some legal repercussions for that. And I tell this, I have represented somebody who called me, just an individual, and he said, I'm being sued by a brokerage because I signed a buyer-broker exclusive agreement, and then I decided I didn't want to work with that guy because I didn't like him anymore, and I went and I just bought something with a listing agent for a property that I saw. They had a really good argument that broker compensation was due under the buyer-broker agreement. So it not only has implications for you, it has implications for the buyer, it has implications for the brokerage. So if you're going to use a buyer-broker exclusive agreement, buyers need to understand that, like I said, it's a good thing because hey, we're working together, that's part of it, that's what I'm gonna do. But on the other hand, just know that enforcing that may cause problems. So if you're gonna use the buyer broker exclusive agreement, be sure everybody understands what exclusive means. And that's why when I say that you're probably gonna see another form come through from NAR that's a property specific. In other words, it says if you buy this property, then you owe me compensation, but if you go buy something else, that's on you. But that's not the form that we're looking at here today. Yeah. All right, so when is compensation due? It's payable upon closing, or if the buyer were to default. So technically, there's a provision in here where compensation would be due if the buyer defaulted. That's always one of those sticky circumstances, because if the buyer defaults, technically there could be potential for compensation to be due. Buyer's responsible for paying this compensation, and this is where the big change is for a lot of people. So this agreement allows you to negotiate for compensation, but if that compensation isn't paid by a listing brokerage or as a concession or whatever it may be, the buyer is responsible to pay that at closing.
You need to know that.
They need to know their closing costs may be significantly higher under this type of agreement. And so that's an important financial piece that a buyer needs to understand, that if for some reason, if there is no compensation being offered or there are no concessions being offered, that buyer is going to be responsible for paying your compensation, whatever it is you agree to, at closing. So that's very important, and I know that's a bit of a mindset change for some people, but that is really the backbone of this, of a lot of this settlement, is that the buyer is responsible for paying their own brokerage fees. Now, you're authorized to negotiate for those. You're authorized to see if you can get a concession or compensation with respect to that. But in the end, that buyer is ultimately responsible to pay its own fees.
Cover decoupling so that they understand that.
What's that?
And explain that decoupling.
The decoupling?
Uh-huh.
Well, I mean, I have to be careful how we talk about this, I guess. Our listing agreements now have been amended such that the listing agent can charge the seller a fee, and now the seller must either elect or not elect to offer compensation to a buyer's agent. They don't have to offer it, and it's very clear in our listing, and they're not required to do so. And so in those instances, you may have a circumstance where they're not offering the buyer broker compensation because the seller has elected not to offer that, and they didn't agree to it in the contract with respect to it. So in those instances, that buyer is going to be responsible, and they need to understand when they make an offer what the financial ramifications for them are. So
Yep.
I mean, that's a big change for a lot of people in the way that business was done. And I think everybody here is very capable of negotiating this. That just means, though, that from a buyer's perspective, and this is what I talk about, not only are you now negotiating the sales contract on one hand, but you also need to potentially negotiate, if you're seeking it, buyer broker compensation, right? So those are two pieces that need to be negotiated at the time of the sales contract now, where in the past that was something that everybody kind of took for granted, frankly, because that was based on the MLS, and that's where the compensation was displayed and showed, and then that's how it was sort of essentially paid. But now that needs to happen at the time of the sales contract, and there needs to be some agreement. You saw that the showing the broker compensation agreement, and that's a way to negotiate and to make sure that that compensation is going to be paid at closing. All right, so the agreement provides that the buyer is going to pay your buyer broker agreement, that you are authorized to negotiate in the sales contract to try to get payment for that buyer broker agreement. But if they refuse and the buyer still agrees, then they're going to be responsible for paying that at closing. And then the last sentence here is super important, which is that this is more for you guys, but the broker shall not receive compensation from broker services from any source exceeding the compensation agreed to in this agreement, and shall disclose to buyer the amount of compensation, if any, paid by a seller listing broker, landlord to this broker. So you're required to disclose to your buyer what you are being paid on the transaction. Of course, they should know that because it's in your buyer-broker agreement here, but whatever agreement is ultimately agreed to also needs to be disclosed to your buyer.
But don't misinterpret that. If you are selling your own listing, you are still entitled to the commission that you have agreed to for handling the listing. That is not this. It's two separate things. So you will be receiving more money than this agreement, but it's not for buyer services, it's for seller services. Just make sure you understand that, okay?
All right. Yeah, so like I said, buyer exclusive agreement, important to know. If they purchase any property during the term of this agreement, they're going to owe the buyer broker fee. That they're responsible if the seller is not paying either concessions or a buyer broker fee, they're responsible to pay that fee. And you cannot receive anything greater than what is in your compensation agreement. One of the issues that we contemplated on this agreement, and you'll see it on number 6 here, is that, well, what happens if they come over, say from Miami, and they sign a buyer broker exclusive agreement with you? Well, we probably need to limit it by scope. So this means it's automatically limited to Collier, Lee, and Charlotte, which is generally where people here sell. You can add other counties. You could put other counties in there if you wanted to. If you want to drive over to Miami-Dade with them and show properties in Miami-Dade, then go right ahead. But your buyer broker agreement by default is only going to cover Collier, Lee, and Charlotte. You can also limit the scope of that. You say, I'm not driving up to Charlotte County. I don't know that market. I'm not going to do that. I'm going to refer that business up there. Then you could just limit it to Collier and Lee. Or if you say, I'm not going to Lee County, you can just limit it to Collier. So.
Okay. So this is where I step in and say, wait a minute. And you've been in my class, you know what I'm going to say. I don't know all of Collier County. I know specific areas of Collier County. I'm not going to put in Collier County. I'm going to put in the area that you and I agree that we're going to work together. So I live in the vineyards. If I wanted to work only in the vineyards, I would put down the vineyards. People have been talking about putting in the zip codes where they work primarily. The Code of Ethics says if you don't know what you're doing, don't do it. Right? So if you, and this has been, Sean and I are going to figure out something to do about this. But these new rules and regulations regarding condos, and they're putting together all the new forms regarding the condos, if you don't know what all those new laws are regarding condominium sales and what the HOAs have got to do, and the amount of money that people are putting into reserves, all that kind of stuff, if you don't know that, should you be selling a high-rise condominium on the beach? So, I mean, I just want you to think about what you're going to cover in here. If you're going to put down all of Collier County, I got in trouble. I said, I've never been to the Everglades. And they all went, oh my God, what do you mean you've never been? I don't even know how to get there, okay? So I did find my way to Ave Maria the other day. I did that. I know, it's terrible.
Probably by accident, frankly.
No, it was on purpose. I had a buyer who wanted to go, but I had to go first. I had to go see it. So, I mean, it's one of those things, be careful what you put in there, because that's what you're telling them you know what to do. All right? Just be careful.
And that's sort of a risk management perspective that Marcy's talking about, because you can put Collier in there, but do you want to, you're obligated now in Collier County with respect to this. So, yeah, talk to your broker about that portion. I'm probably not going to say too much more about the buyer broker agreement. This is just one form, but it's an example of you really need to understand the form if you're going to ask your buyer to sign it, and you're going to, because we haven't talked about this yet, but everybody needs to have a signed buyer broker agreement prior to touring a home. And touring a home means stepping into that home with your buyer. And Marcy gave the example that apparently somebody drove all the way up to Cape Coral and didn't have a signed buyer broker agreement. And then they said, oh, well, before we go into the showing, sign this agreement here. Well, I mean, that's a terrible idea, right? Because, you're not properly explaining it to them. You're asking them to sign, right when you walk into the showing. And my understanding is they said, no, I'm not signing it. And then they couldn't show it. So that was a big waste of time for everybody, right? Let's not do that. And so please be able to, you're not lawyers, but you should be able to at least explain to them what the expectations are for them and for you with respect to your buyer broker agreements, whether it's this buyer broker agreement or another buyer broker agreement that your brokerage has, or a Florida form. You need to become very comfortable, just like you are with a sales contract, or just like you are with a listing contract, when you go to have your presentations with your sellers, like, what does that mean that I can't display it on the internet? And sort of like, you need to be comfortable answering their questions. You're not a lawyer, but you're gonna have to explain to them this legal form that you're asking them to sign. And so please be comfortable with your buyer broker agreement. And that's my big takeaway for a risk management perspective, is that whatever form you and your brokerage use, be really comfortable and understand what you are both agreeing to up front.
And so here, what we're talking about is we keep talking about the fact that when we say buyer brokerage agreement,
Yeah.
right?
Yes.
So we, in fact, have the board of directors made a motion to change the way it's worded in the MLS now. It has to be an agreement that meets the qualifications for the settlement. You want to cover what's up there?
Sure. Yeah, I mean, it's pretty straight, I mean, I hope everybody's heard this all by now. And that how can a buyer compensate the concession? And please, does everybody, concession does not equal compensation. I say this at all of my meetings. I know a lot of people here, but they're not the same thing.
They want to know the difference.
They want to know the difference. Please think of a concession as a closing cost and a prepaid. That's what a concession is. Whereas compensation is generally the type of a commission or other monetary amount being paid directly to a buyer's broker. A concession is simply, I'm sure everybody here's done a lot of transactions. You see it, I'm going to give a credit at closing, towards X, whatever may have happened. It helps reduce the cash to close for the buyer, right? Because one of the items that a buyer may now have to pay at closing is their broker compensation. So their cash to close could go from here all the way up here. And now a concession would help reduce, whoa, we're way up here, that concession would help reduce that cash to close number. Whereas a compensation is typically not going to be something that is going to be paid usually to the buyer's broker under that broker compensation agreement, and it's not going to be paid to the buyer, it's going to be paid to the buyer's broker with respect to it. So.
Perfect. All right, so next on our list is to talk about the exclusive versus non-exclusive agreement. So Sean has covered what it means to have an exclusive agreement pretty solidly. What if a buyer says, I don't want to sign an exclusive agreement with you? I want to be able to go and look at houses and properties with whoever I want to. And a lot of them may decide they just only want to work with a listing agent. We've had buyers say, I'm just going to go work with a listing agent. They know the most about that house. That's what I want to do, so I'm not going to sign this. So that's why we have the variety of forms, like the touring agreement and the showing agreements, that you can use those in that particular case and then try to build a rapport with them so that you eventually could get them in to do the buyer counseling session and to sign them up on an exclusive agreement. Now, I know some brokerages are requiring an exclusive agreement, and I know some buyers who have said, I will never sign an exclusive agreement. Dave from Minnesota and me from Iowa and South Dakota, we have been working with these agreements, exclusive agreements, since 1995. Required, since 1995. The only difference those people are experiencing right now is that there's no compensation offered through the MLS. That's what they're struggling with. And you have to now struggle through all of this. So the buyer counseling session that we did for you, the buyer listing presentation that we did for you, all being able to get the buyer in to talk. The one thing you just can't do is stick this underneath their nose and say, sign it, or you won't get to see the property, right? I mean, you can try it, but be careful. How many thought about the fact that that could be, they'll say no, right? Right? So, yeah, absolutely. So they might say, I'll sign something else. And that's why we are, and Sean spent Saturday here, along with Sam, rewriting forms, creating forms for us to use. And My God, the Legal Resources Committee has spent hours and hours and days putting these forms together for you. I mean, bow down, hug, kiss, and whatever you want to do.
Don't do that.
Don't do that. But, I mean, it's really important that you understand that that's what those other forms would be for then, instead of this, unless your brokerage is requiring you to have a buyer brokerage agreement, and then you have to follow the instructions of your broker, but however they want to deal with that. But just know there's a huge difference between the non-exclusive and the exclusive. In fact, there are some touring agreements out there that say, you don't owe me a dime. Like, I'll just show you the house. Come on, let's go.
Yes, just be very careful that your touring agreements comply with the terms of the settlement, and that's all I'll say on that, because I've seen a lot of touring agreements out there, but one feature of a touring agreement is that there is no promise of compensation usually in a touring agreement, and it just simply says that at a future date, this is what it would be. So just know that making sure you understand the form that you're asking people to sign and what the benefits are of it and what the downsides are of it. So long as it's compliant with the terms of the settlement, that's up to you and your broker and whatever you want to do. We're working hard to get you other tools. And like I said, Marcy did indicate we had a very long legal forms meeting on Saturday for 6 hours. We have a couple of new forms, knock on wood, coming, like the property-specific buyer broker or buyer agreement, where you can just say, we'll just go take a look at these 5 homes, and if you buy any of these 5 homes, this is the compensation that you would owe me on it. Where you don't have the same, oh, by the way, if you buy any other home in the next 6 months, you owe me money on it. But I would bet you that if you sat and you asked your buyer, you said, do you want an exclusive agreement or do you want a non-exclusive agreement? They probably look at you and go, I have no idea.
What that means, right?
What that means. So you have to at least be able to explain what that means. I mean, as a lawyer, I get people and they come in and they say, well, I said, did you sign an as-is or did you sign a regular sales contract? And they go, I have no idea. You never assume that they have this level of knowledge. I mean, you're comfortable talking somewhat, I assume, about exclusive versus non-exclusive, hopefully after this, but your buyer may have no idea what that means. So just be really clear about it.
All righty. Now, number 7, form to release confidential information. If you were in my class last week, we talked about, I was teaching Code of Ethics, that's what I was teaching. So we talked about the fact that Standard Practice 1.9 plus our law says I can't release any confidential information that I have, for example, about my seller. So that's price that they would accept other than the listed price, terms that they would accept other than the terms that are in their listing agreement. Price, terms, motivation, why are they selling? And the 4th one is anything that would hinder their bargaining position with the buyer. Price, terms, motivation, anything that hinders the bargaining position. So I use the example of I'm at an open house and a buyer walks in and they ask the same 4 questions every time. What are they? How much is it? Have there been any offers? How long has it been on the market? Is it negotiable? Where are they going? Why are they selling? All of those things, right? So you can't tell them that. Do you know that? You can't tell them that. If I call you on the phone and I say, I'm going to go show your property, is there anything I should know about it? And you say, bring me an offer. The man's driving me nuts. Just bring me something. He's negotiable. What have you just done? Violated the Code of Ethics and you violated the law. So here's your easy solve. Now sometimes people do this in a listing agreement, or I created a form that I've used that says the release of confidential information. And I say to the seller, they have the same 5 to 6 questions every single time. They have it. I said, would you allow me to disclose to them these things? And then, for example, you're flexible. Price is negotiable, yes or no? So, well, it depends upon the day. Okay, I'll say that, depends upon the day. All right, now, why are you moving? If they say, because we're building a new house, and you say that to a buyer, they might say, oh, really, when's the new house going to be done? Well, it's almost complete. Oh, so they need to sell to close. Is that something that could hinder the bargaining position? Yep. So think about what it is you're saying and how it can be used. So the easiest way to do this is to get the confidential information, able to disclose what they want you to disclose from both the buyer and the seller. Because if the buyer says, look, we've got to be down here, we're opening up this new business in 30 days, we've got to get down here and find something, is that an urgency to buy? If the buyer says to you, I love this house, I think it's a little overpriced, I'm going to come in here, but if I have to pay full price, I will. You're not going to disclose that stuff. So if you think that there's confidential information that would benefit the negotiations, then get it in writing that you can disclose it. Does that make sense? Okay. Now, let's talk about the buyer brokerage agreement. The exclusive buyer brokerage agreement, or non-exclusive even, belongs to the brokerage. So all y'all, we're one big company, and I bring in a buyer brokerage agreement, I hand it to my broker, Sean, and now all y'all represent my buyer as well. So now I have to go to the Florida Realtors Convention tomorrow. I'm leaving town. So what if my buyer all of a sudden says, well, I need to go see that house listed over there with XYZ Real Estate. That means I can call any of you up and say, would you please go show this listing for me? And you don't need a buyer brokerage agreement because the company already has it. If you were in our brokerage relationships class, how many of you took that class with Amy and I, brokerage relationships? So you learned, right? That the whole company represents that buyer, just like the whole company represents that seller. So understand the buyer brokerage agreement belongs to the brokerage, and anybody within that brokerage can show properties to your buyer for you if you're gone. Make sense? Okay. Now, let's talk about showing houses, or you want to comment on that, Mark?
No, I mean, I just would keep in mind when you look at your agreements, I mean, on the top it says broker. It doesn't have my name as the licensee, it has your broker. Just like listings are brokerage listings, buyer broker agreements are gonna go with respect to the broker. And I think that's probably also something to consider too, you know, where if people are leaving one brokerage to go to the other, they're gonna have to figure out what that looks like, just like you do with listing agreements. You're gonna have to figure out what that looks like with your buyer broker agreements as well. Because remember, it belongs to the broker, not to the individual agent. That's just that's the way it's set up here in Florida, so.
Yep. All right, so showing in-house listings. So one of the things I hope that the brokers have done is try to figure out a way to let you all know what all of the sellers who have listings with your company are compensating or cooperating, okay? Or if they're cooperating. I was asked by one company, what do you recommend? And I said, I like an Excel spreadsheet. An Excel spreadsheet that you keep on the OneDrive that's updated all the time, has a list of all of the listings that your company has, and it has the compensation that those sellers are paying you, so you don't have to call everybody within your own company to see if compensation is being offered on your in-house listings. Does that make sense? Okay? It saves a lot of time, doesn't it? And then one of the other things you're going to need to figure out is using templates. If you're going to ask other companies what their seller is contributing to the compensation, or if they are, think about developing a template you could send and say, what's the compensation? And on the other hand, we're going to cover it in a minute about what happens when people get to you. So just think about showing homes that are your company's listings, how you know how much you can get paid showing your own company's listings. That would help, right? All right, let's talk about open houses.
Yeah, real quick, just on the in-house listings, just since putting my MLS hat on here.
Yep.
Each brokerage on its own website is allowed to display whether it is or is not offering compensation for its listings. It cannot display compensation for listings that are from other brokerages.
That's coming up on an
So I want to be very clear about that, and I that may be another piece with respect to that. But so there's that, and what else was I going to say on this? Yeah, just keep in mind That only relates to your own brokerage's listings, though, and you can display that internally or externally, so long as it doesn't use our MLS pieces to do so.
All right, so open houses are, if you are representing, now let's switch our hats. Now we have a listing, and y'all represent my seller, right? We all represent my seller. I brought the listing in, you all represent my seller because we're one company. Any of you can do an open house on my listing, and I can do an open house on your listings just fine, because we all represent the brokerage company, and the brokerage company represents the seller. Now, I have an open house, and a buyer walks in. What NAR has said, and we have followed suit for Florida Realtors in here, what NAR has said is that buyer doesn't need a touring agreement because we represent the seller. And the only time you would need to pull out any one of the agreements would be when a buyer says, I believe I'd like to make an offer on this. And then you have to disclose who you are and how you're being paid and the 4 components that's required, right?
Yeah, so long as you're representing the seller solely, then you don't have to have that agreement. And once that transitions though, and then they say, oh, I want to go look at the house down the street, I mean, you're going to have a buyer broker agreement with respect to that, because it's, no longer
An agreement.
an agreement that complies with the terms of the settlement. You'll hear me say buyer broker agreement, but just a buyer agreement, a buyer compensation agreement that's sufficient. That's a mouthful though, I don't know. But just from that open house, right? So you can sit there, anybody that walks in, you don't need to have that agreement. But once you transition to doing something more with that buyer and you're leaving that home, be very careful, because once you start doing anything, including if you're going to show them a home that's not your brokerage listing and you're taking them there, you're going to need to have a buyer broker agreement, and they're going to have to sign it. So I've said to people, they said, should I print them out and bring them with me? Yeah, it's not a bad idea. Whatever form you want to use, if you're doing an open house and you think there's a chance that they come at, we've all been there, they come at 355 and they're like, oh, not this one, but I saw the other one down there. I mean, if you want to go show them, okay, well, all right, we'll put the agreement together and we'll go do it. But you have to have, you can't just be like, oh, don't worry about it. You're going to have an agreement signed with them. I know it's 355 and you're like, I got to get home, but that might be worth it. Have some agreements with you, right? And be something that would work for you.
Yeah, and probably not the exclusive buyer rep agreement.
Probably not an exclusive buyer rep agreement, but whatever works for you guys, though.
Whatever works, right? So that's when you would use that touring agreement or a pre-touring agreement, whatever it is, just to get you down the street to show that other house. Because you need to build the rapport. You need to build the rapport to be able to get into the buyer counseling session and then get the exclusive agreement. That's after 30 years of teaching buyer representation. That's the key to getting it done. So open houses, now like I said, anybody from your company can do an open house on any listing. Always check with the seller though to make sure that they're comfortable that somebody else is in the house instead of you. That's the only thing I would caution you about. All right, next. All right, so Sean's favorite thing, MLS. Well, is it MLS or law first? Which do you like best?
I'm a lawyer first, so it just so happened that I became very involved in the MLS, and I'm also a realtor, just in case you couldn't tell from some of my other.
In fact, tell them about your deal you just had.
Well, okay. I would just say here that, I had an opportunity recently to list a home, and I used our new listing agreement, and my only feedback is it was fine. Everybody just called me and they sent me a text or they sent me an email and they asked me, is your seller offering compensation? And I would say yes or no. And if they're offering compensation, what is it? And then we would send along the form, the broker compensation form, and it was fine. I don't know if anybody's had any other experiences out there, but I think we had like 13 showings and 5 offers in like a day, and everybody was really good about it. So my only feedback from that perspective is that it'll be okay, and that there will be people that misunderstand or don't quite understand everything, but we'll get there and it'll be fine. And we'll all work through it. And I thought it was just, and I guess that leads, Marcy, because people were like, well, we're gonna put something in the MLS, we're gonna doctor the photo in the MLS. And I said to them, I said, you're gonna spend more time doing that than if you just picked up the phone and called or texted. If that's an important piece, then like you would be spending more time doing whatever ridiculous things that you're doing. Like I heard somebody in California was like cutting the grass and like taking pictures of, I mean, something ridiculous. It's like, how much effort and money did that take to cut that into the grass, instead of just like calling somebody up and like saying like, are you offering compensation? And if you are, what is it? Like, how hard is that to do? I know we don't always like to have to get on the phone. And the other thing I thought was really nice about it, though, was it was a good foray into that conversation between you and the buyer's agent, where you could establish that relationship, so that, I know I always feel better when I'm like, oh, I spoke to them, they're on top of it, they know what they're doing, I feel good about this offer versus this offer, right? Like, I think that's a nice foray into that conversation, and it was just no big deal.
And by the way, then you also know that they are going to work with you together on that. I think it's really nice, instead of not have that conversation. All right, you're up. MLS rules, this nice little thing that they just put out.
Yeah, I mean, okay, we'll talk MLS rules, and I'm sure everybody's seen them and the pop-ups and the other piece with respect to it. Obviously, this is a buyer rep class, essentially, but, in terms of listing, you cannot use the word compensation, commission. If you put the word bonus, I know Cindy will flag that. That doesn't mean you can't say bonus room, but she will flag bonus, and then she'll look at your listing to make sure that it's correct. Things like buyer broker friendly, commission to be paid upon success, like none of those things are going in our MLS. So don't be looking for them as a buyer's agent. You shouldn't expect to see them. You can advertise concessions, and concessions as a buyer's agent, you can look in the confidential remarks. And what we're encouraging people to do is, if you are offering concessions, to just say that the seller is offering concessions. It is our preference. It's not a rule right now. It's our preference. We strongly encourage you not to use percentages or dollars for concessions, for a lot of reasons, for enforcement and other reasons with respect to it. That's an avoid. It's not necessarily a requirement, because people still have a really hard time, the difference between concessions and compensation. My mother's a realtor, and I talk to her all the time, and I still talk with her about, she's like, well, wait, because we just never use the word concessions, right? Like, I've been closing deals here for 14 years in Naples, and I don't think I've ever heard the word concessions with respect to, I've heard closing costs and prepaids. Like, that's a term that we use here. We just never use the word touring, and we never use the word concessions. So that's just new vocabulary that we're all getting used to. But concessions can be in the MLS, in the confidential remarks. So if you're looking as a buyer's rep for those, they can be there. And then, as Marcy indicates here, we have the 2-click options, which means that you are allowed to put a hyperlink to your own brokerage's website in the confidential remarks. And since you are allowed to display compensation on your own brokerage's website, that can be displayed on there, but you cannot link directly to compensation from the MLS. So I hope that makes some sense. So when you click on it in the MLS, it cannot go directly to compensation. It has to go to some landing page there, and then one more click, and that would take you to compensation. And that's part of NAR's guidance. So there are ways, as a buyer's agent, if a hyperlink is being put into confidential remarks, which we do allow, it just cannot link directly to an offer of compensation if there is one. Doesn't mean that there is one. And I just want one other point. Maybe you make this somewhere else in here, Marcy. You just because compensation is not being offered or concessions are not being offered does not mean that as a buyer's agent you cannot ask for those things in a sales contract. And I know that's probably in your side. Just since we're talking about that, you can always you've heard the phrase, it's always negotiable. It's always negotiable. So even if it's not being offered or advertised or whatever it may be, you can still ask for it. So.
And then regarding the 2 clicks, NAR just changed it so it doesn't say website, so it can be a landing page. So, can I talk about yours? Okay, so it can go to a Google Doc, right? Huh? Google Drive, where you can have all of your listings listed there, and it takes you to that listing. You click on that listing, and now you've got 2 clicks. So it's a great idea, way to do it, but you don't have to have a website. They changed that just 2 weeks ago. Yeah.
I still think it's easier to just call up and say, hey, what are you
He
offering?
does. But, you know,
If you are, like, all right, I still think that's fine, but yes, by the technical letter, you can do the 2 clicks, and we even had to wait, when do you start counting the clicks? And we had to determine when do you start counting the clicks, and essentially you just cannot directly link to compensation from the MLS.
right.
So,
All right, so we've already talked about the compensation in the buyer rep agreement. We already did that one.
Yep.
All right, so 13 is asking for compensation from the seller or the seller's rep. And like Sean said, you can always do it. You can always do something to ask the seller to pay. So when I started teaching this back in the mid-90s and for NAR, they gave us the verbiage to use if you were going to do that. And you've got attorneys to talk to, you've got your broker to talk to, but what they taught us back then was we could write into a purchase contract that this offer was subject to and contingent upon the seller reimbursing the buyer at closing this amount, or reimbursing the buyer at closing this amount, and the offer was subject to that. And that's something that could be countered, right? So get some phrase that a lawyer has approved in some way, shape, or form, right, sir? Before you start writing anything into a contract. Got it? But it's easy to do it that way. But it has to be, if you want it to be a part of the contract, it has to be subject to that.
yes, and we are hopefully going to be offering an addendum to the contract, which will make the contract contingent upon a broker compensation in whatever amount is being asked for. So hopefully you won't have to come up with language on your own. Hopefully you'll have a form soon that will sort of relate to that. So I always couch it because, it goes through committee, and we debate it for hours, and then it has to go to outside counsel for their review. And, so there's a process there, so I can't tell you 100% yes, it'll be there, but we do recognize the need because it matters. For example, if you have a buyer and they're making an offer, and you have a signed buyer agreement, and they're gonna pay X compensation, well, they may be financially understanding that they don't have the cash to close unless that compensation is being paid by the seller. So you need to make sure that your offer is potentially contingent upon that seller paying X, because otherwise the buyer may just not have sufficient cash to close. So we are hopefully going to have an addendum to the sales contract that will make the sales contract contingent upon a broker compensation agreement, which is in your packet, a broker compensation agreement being executed within X amount of days, and I think 5 is the default, so that your buyer feels comfortable knowing, and you, by the way, feel comfortable knowing that your compensation has been agreed to, is guaranteed, so to speak, which was, part of where we were at before, which we now have to make sure that it's properly documented now. Yeah.
Okay, if you have filled out your questions thing, we're coming around and picking those up. So hold your hand up if you've got them so that we can get those and bring them on up here. All right, listing broker's responsibility for responding to requests for compensation calls. Have a plan. And what I've suggested to our brokerage is that, again, you can have it either in a text or you can have it in an email, and like Sean did. He had his broker sign it. I said, it's just a template, it's got the signature of the broker in it already, you just put the address up and you put the amount of money in and you send it on over, either by text or by email, so that you don't have to necessarily call back, right? Because we're all busy, or at least we hope we will be busier, let's put it that way, but just have a plan on how you're gonna do it and have it ready. Every single time you list a house, just get it in there, get it done, then you always have it. Want to add to that?
Sure. Briefly, if we can just go in your packet, you should have a form called Broker Compensation Agreement. I just want to make sure we're on the same page about the forms that we're talking about here. I'll give you guys, a sec.
Is it in there?
Yeah, well, it's in my package.
But it should be in there. It's the first form.
It says, at the top, it just says Broker Compensation Agreement. All right.
Okay.
Okay. Yeah, I don't know where it is in your packet, but So that, what Marcy's talking about is the broker compensation agreement form, and this is a new form, and like I said, I cover this in depth in the July 31st webinar you can take a look at, but this is the type of form, doesn't have to be this form, this is the type of form where there's an agreement between a listing broker and a buyer's broker with respect to the following property, with respect to the following buyer, if they are offering a co-broke, what that amount will be, which will be paid at the sale, which will be paid at the closing on the property, so long as they are the procuring cause and that it actually closes, right? So this is the type of form that Marcy's referencing, where I, frankly, as a buyer's agent, would want to see some version of this with respect to whatever is being offered, if that's what I'm negotiating. So this is the type of form that you would be looking at, and this form exists. This is the type of form that, for example, whatever your brokers, by the way, each broker is going to have their own policy. Because I've talked to some brokers that said, well, I'm not going to pre-sign this form, I want to see what, that, you got to talk to your broker about that. Some brokers are comfortable signing this form, so I don't want to, I'm not putting it out there that they all have to sign it, like that's not, I'm not saying that, but this is the type of form that you're going to want to make sure is executed to verify that the compensation is actually going to be paid as to what you're being told that's, what, if it's being offered.
Okay, you want to bring those questions up here? Bring them on up so Sean can start going through, looking through, maybe we can categorize some of them.
But I do want to talk about the listing agents.
Yep.
So there's been a decent amount of discussion, but what if the listing agent won't tell you, if you ask if they're offering broker compensation, what if the listing agent won't tell you? I'm sorry, what's that?
Thank you, dear.
Or the broker. So we put these questions to NAR's attorney the other day, and it was consistent, and some of this, like, it's not an MLS rule, so I'm not sitting here, as with my MLS hat on. You have a listing agreement that if the seller has elected to make an offer of compensation, they legally have a requirement, the broker does, to make that offer of compensation. So the listing agreement now sets forth an offer, if they've elected it, a specific offer of compensation, they have a legal requirement to do so. And that is, that's what the seller has agreed, right? That's what the seller says. If you can find somebody who's ready, willing, and able to purchase, here's what I'm willing to pay for that. The listing agent has that. The brokerage has a duty to follow the listing contract. And then NAR also spoke about, from an ethical perspective, and your requirements that you have to fully disclose all the details, and playing around. I've heard some people say, oh, well, they say something different. I mean, that's just a terrible idea, right? Because obviously you've got a listing agreement that outlines this, and you also have other duties to be fair and honest and transparent in your transactions. So, that's...
Well, and the other part about that is in your listing agreement, or any agreement that you got with the seller, whether it's listing or a for sale by owner agreement or anything like that, you have put a number down. And what I'm hearing in class is people saying, well, the seller just wants to wait and see, and they want a copy of the buyer rep agreement. By the way, they don't get a copy of the buyer rep agreement. They don't get it, right? That is yours and the buyer's. They don't, if somebody asks you for that, I say go pound sand, but it's not really nice. But anyway, they don't get that. So, but if the seller puts a number in the listing agreement or any agreement that you have with them, that's the number you have to say. And if the seller says, well, I just want to wait and see what the offer is, and then we'll decide, fine, then put, no, the seller's not compensating, right? On the listing agreement, you put, no, the seller's not compensating. That's what you put down, because what they're saying is they're negotiable. All right? So now, the last thing that's on the little list, and then we'll start going through these, is a business card. So back in the day, when we started this whole thing in the mid-90s, we always encouraged the agents to have a business card made up that said, you gave to your buyer, and it says, Marcy Rogo belongs to Sean Gary. Right? And so when they go into an open house, they can just say, there I am. I've got an exclusive agreement. I belong. And it helped a lot. I mean, it really helped a lot, because then it was just real upfront. And we just thought it was the best thing since sliced bread. And it just says, Marcy Rogo is a client or a customer of XYZ Real Estate. If you have any questions, the listing agent is this name. And just think about how to make life easy. All right. The other thing that's in your packet is the rest of the courses for the rest of the year, or the rest of this little period of time that we have, actually, that we all put together for you. So the buyer brokerage agreement, how to implement it, that's on Monday. And then what exactly is antitrust on the 28th. Sean and I are going to be teaching that. Then we have an ABR class coming up with Amy Reinhold. I'm doing Understanding Procuring Cause, September 20th. And then we have another Lunch and Learn, Be Aware of Buyer Representation as it applies to fair housing. And then on the 14th, we've got a buyer brokerage agreement, how to implement again. A couple of those, and one in Spanish. Christina Davido is going to do that. She's like the best. And then November 18th. And there'll be others, contract updates and stuff like that. But the sessions that we put together for you end with Brett's on the fair housing. And then we've been asked to do a couple of them over again. So let's go.
Not that Marcy's, busy at all, right? I mean, and I just have to say, Marcy, you do a great job, and it was neat for me to see you talking to people and getting to shaking their hands, and, everybody knows, I mean, Marcy, she does an excellent job. So I'm just here, just to add a little color commentary.
You're doing a great job.
So I'm gonna just go through these questions one at a time, and
Yep.
then, I'm just gonna ask, I won't give the name, but when showing an MLS listing, which is your listing for a property you own, do you still need to have a showing agreement? Well, we talked about this a little bit. So long as you're acting solely for the seller and you're not representing a buyer, in other words,
their house.
then you don't have to have that agreement. Now, from a risk management perspective, I might suggest that, it probably wouldn't be the worst idea to have that conversation with the buyer about getting that buyer agreement in place. But on your own listing, so long as you're only working for the seller,
It says your own listing, or
which
we are the seller?
is your listing.
Okay.
If it's your listing, if you're working for the seller and it's your listing, that. But I think from a risk management perspective, I think it gets a little bit complicated because the moment that buyer starts asking you stuff, which putting an offer in, all these other pieces, I think you're really in getting into the place where maybe you're not just representing the seller's interests. So that's just my opinion from a risk management perspective. That is a technical legal matter. When you're solely representing a seller's interest, then you don't have to have a buyer rep agreement, and that's very clear. But at some point, that line becomes a little blurry, in my opinion, from a risk management perspective, and I would think you would be best served having a buyer broker or a buyer agreement at some point with that buyer.
All right, I'm going to hand this one over to you, but first of all, one of the notes on here is classes with scripts would be very helpful for explaining buyer representation agreements to the customers. All right, where's that schedule of classes?
Now you've done it.
Yeah, I know. Monday, no. There we go, Friday the 13th. Oh dear, how did I do that? So on Friday the 13th, you all come, well, I shouldn't say all come because it's going to be a limited amount of people. We're going to have, in this room, we're going to have 8, we'll try to get 10 round tables, and there will be 8 or 10 of us, instructors, at one at each table, and there will be a topic at each table. And when you come in, there'll be a packet in the back that you can pick up that will tell you who's doing what at each one of those tables. And then there will be chairs. I think we're going to try to get 10 chairs around each of the, so it'll be double-decker like. So we can get in about 80 people. So if you haven't signed up for that now, you might want to do that, because that will be one of those classes that if you've got a name down, it's probably a good idea. Anyway, we will be role-playing with you, and I like to use the word skill practicing with you, and we will have certain dialogues. Each one of us are going to have some stuff to give you, and we'll answer any questions that you got or give you any dialogues. So that's going to be, we heard that scream, and that's where it is. Okay, now answer that question.
Okay. Where do we write on a sales contract that our offer is contingent on compensation to a buyer's broker? So I want to strongly caution you to make sure that you are consulting with your broker and appropriate legal counsel before you just start writing stuff on contracts. specifically other terms and conditions, which can be considered the practice of law in Florida by putting stuff in there. As I indicated, there is hopefully an addendum with respect to that, but I would check with your broker. I have heard people are putting stuff like that in the other terms and conditions, but be very careful about it because it does matter. So that would be an example of why there may be an addendum to the sales contract, so you don't have to worry about writing in other terms and conditions, those types of things. So,
This is a good one.
all right. We should have like the speed round and be like, go, go, go. All right. How is the MLS being monitored? So the MLS is being monitored. So as we indicated, there are keywords that we have what we call a listing data checker, and it actually checks all the listings to verify that certain words are not being used in it, and then it will flag it, like I said, bonus, for example. And then staff here at NABOR is then checking those listings to see whether it was just either an inadvertent or, was it a bonus room. And there are AI technology, and that is being implemented as well. One of the things that we're looking at is monitoring supplements, because you can't upload supplements that, like that broker compensation agreement. You couldn't upload that into the MLS. But right now we're working on that. But really the way is if you see something, I hate to use the words, if you see something, say something. But that's sort of where we're at when it comes to like supplements or pictures, or we've had reports from people. And it's not worth it. Please, it's not worth it. It's a $1,000 fine. And, this is a settlement agreement that we must enforce, and we must be very careful about how we enforce it. So,
I'm coming back to these, but these have numbers in them for right now, so I gotta reword them. So a buyer can do a tour of homes without signing a buyer long form. I thought you couldn't see or show without a form. You can have a form. It doesn't have to be the exclusive buyer brokerage agreement. I think we've said that over and over again. It can come a touring form, it can be any of the forms.
so long as it complies with the terms of the settlement.
Is that your question?
No. What? See, you can-
No. Because we're on tape. No, we're on tape, so we'll answer that after?
Oh,
All right.
I like this one. What's the difference between compensation and concessions? All right, we talked about that earlier. That's one of my favorite topics. Once again, think concessions, closing costs and prepaids that are happening to closing. Compensation relates directly to buyer broker compensation, for example. The other important piece is that if you're offering concessions in the MLS, it cannot be tied directly to any broker compensation. So I won't belabor that one, but closing costs and credits are a concession. Yes.
Since we cannot use the banned words, how do we write what our percentage of pay commission is on the sales contract when we're a buyer's broker? Oh, that's where you can use the word.
You're allowed to use any of those words so long as they're
words.
not in the MLS. You just cannot use those words in the MLS. I had somebody say, well, I asked a listing agent, what if they're offering compensation and what is it? And they said they couldn't tell me because they weren't allowed to tell me that under the settlement. I said, no, it's just in the MLS. You're not allowed to tell them. It's not like a game of, whatever it might be.
Somebody
So,
asked me the other day, they said, well, if we're not supposed to use numbers, how can I explain my compensation to a seller? And I went, use the numbers. I've got you so well trained, you know how to use the numbers.
All right.
I don't mean to scare you.
I like this question. If a listing agent asks, if asking a listing agent if seller is offering commission, is a text message adequate and does it suffice? Well, that's between you and your brokerage of whether it suffices. I can't give you legal advice. If it were me, I would want to make sure I have a fully signed broker compensation agreement with respect to it. That's what I think is probably your best bet for ensuring your compensation agreements. Is it better than, oh, they told me over the phone? Sure, but is it as good as a broker compensation agreement? No. So do with that as you will.
All right, so this one is, can I use a mix of NABOR and Florida forms? So,
You're looking at me. I heard somebody like exclaim in the back because I know that's one of the big things that they talk
big
about.
questions. But if I'm using Florida Realtors touring agreement, because we don't have ours yet, I can use that Florida Realtors form. Isn't it when I'm using a contract, all the addendums that go with that contract have to be from the same place?
Yes. So, typically, look, are there circumstances where, I'm going to get in trouble, where you can? Yes. But so the problem is that sometimes the forms refer to the other forms, and they refer to the specific sections of the other forms. So you can't use any forms that, conflict. But a buyer-broker agreement typically is not tied into another form, and so therefore you're okay. It's not tied into a listing agreement, it's not tied into a sales contract. So you're okay there, but to the best you can, try to be consistent, but at the moment, we don't have a non-exclusive touring agreement, so that you may have to look to Florida Realtors for that, so. Okay. Rentals. Rentals are not actually covered under the settlement agreement, and so while the compensation may be out of the MLS, technically the requirements of the settlement agreement at this moment do not apply to rentals. So technically or commercial, you don't have to have, for example, a buyer-broker agreement. I know you hate that word, but a buyer agreement if you're showing rentals under the settlement agreement. Is it a good idea so you can let everybody know up front? Sure, I think that's probably a good idea, but yeah. All right, monitor if buyers have signed, I like these questions. These are good questions,
Aren't they though?
everybody. So monitor if a buyers have a signed agreement with another agent. It's not the listing agent's job to monitor, it's an MLS enforcement. It's similar to if you have a listing agreement. You don't turn your listings agreement into the MLS, but if you're ever asked if you have one, you better well be able to provide one that is compliant with the terms of the settlement and the buyer-broker agreement. So nobody here at the moment is going to be asking anybody to provide their buyer-broker agreements, but you better have one that's compliant if you are asked, because somebody can, just like a listing agreement where they challenge or they ask to see a copy of it. So that's the answer there.
Go ahead.
Oh, okay, all right. Does broker compensation agreement go with the contract? We talked about this. I think it is a good idea to have it signed at the same time or ahead of time. That depends on your broker policies and what they're allowing, because some brokers are pre-signing those broker compensation agreements and some brokers are not. But I think this will all be solved once we have the addendum for the contingency for the broker compensation agreement. But you can write into the sales contract. You are allowed to write into the sales contract concessions, compensation, whatever it is, you are allowed to write that into the sales contract. So if that is what you and your broker are comfortable with, you're allowed to do that. That does not violate standard of practice 16, if in case anybody was curious about that. Okay. If you want to touch base on that one.
How is exclusive buyer agency agreement enforced? Can you share the form to release confidential information? Sure, whoever, Nancy, just see me after. So how is it enforced? That would be up to you and your broker.
Okay, question was, when a customer wants to scratch off any line in a listing or sales contract, no, don't ever scratch off lines and initial. Anytime you start playing with the listing or the sales contract, you are getting into the practice of law. Please check with your broker. I'm sure they have policies with respect to that. And bonus language, that would be up to however you guys want to handle it. But your buyer broker agreement is limited to the compensation amount with respect to that. And I'll leave it to whoever your broker's lawyers are, how they want to handle any broker bonus language in that. Do we need a signed agreement for showing a rental property? The answer is no, it doesn't apply to rental properties. Do I think you should have one? Yes, I think it would be a much easier conversation now that we're doing that, but don't have to.
Well, I don't know, I'd have one signed because you know how much work, it is to go find seasonal rentals, right? How many days and weeks do you spend on a computer and then you're going out looking and we've never gotten paid for that unless they lease something? Oh, that's the one place I'd have one.
Rentals are interesting. All right, enforcement. And I think, I'm not going to read this whole question, but I do think it matters. I mean, in terms of, remember, your buyer broker agreement is with your broker. And it's up to your broker how they want to proceed on that. And different brokers have different models about enforcement. You may say, oh, this is a longtime client of mine, we're going to do something different. It's really up to your broker. And that I cannot tell you, because they're going to look at legal advice, they're going to look at all sorts of options about maintaining that relationship and history, and they're going to do a whole calculus about whether they're going to sue a buyer. Is it right? I mean, that's what we're talking about. Are you going to sue a buyer? Just like a listing agent, when they don't get paid or there's a problem, are you going to sue that seller? Are you going to sue them for the half deposit that you should be paid because the contract terminated under the strict terms of the listing agreement? You're entitled to half of that deposit or whatever your listing agreement says. Are you going to sue that seller? I can't answer that question. The legal rights and responsibilities are there, and that'll be up to whatever is done there. And people make their own judgment calls. And I'm a reformed litigator. I used to litigate. Now I just do real estate transactions, trust and estates, and that type of thing. I like that. You better have a really good reason to litigate. Very expensive, very costly, very difficult. So, but that's up to each individual broker is how they want to handle that.
Okay, this is a really, really good question. When working with buyers who don't speak or don't read English, is it okay to prepare a buyer's rep agreement in their native language for them to sign? This became a huge problem way back in the 90s when we started this, because we had so many people who did not speak English, didn't read English. Yes, and there are services. The Catholic Social Services prepares documents like that. We've got people who, Christina Davido is fabulous as far as Spanish is concerned. But one of the things, you've got to find somebody who really don't go into Google search and say, how do you say this in this language? You've got to find somebody who really knows that language and can correctly do it. The one thing you do not want is for their child who does speak English to translate it for them. And that's what was happening, and that is what's happening. Don't let that happen. Find somebody who can put it in their native language. In a couple of states, you know what they do? They have English on one side, Spanish on the other. Now they have to sign the English side, but it's correct on that side. So if that's something that you're dealing with, make sure that you get somebody who knows, because there are all different ways, all different dialects in Spanish. So, but don't let anybody interpret it for them. Don't let them.
Yeah, I have a hard enough time as a lawyer explaining these terms to people that are very, speak English. So, just be very cautious about those types of things, and sticking papers in front of people who don't understand them and making them sign it. It's not a good idea from a lot of perspectives. So, okay, can you call a listing agent directly and ask if their seller absolutely just can't do it on the MLS, right? Just the big takeaway is offers of compensation are no longer allowed to be communicated on the MLS. You can call them up, you can text, you can whatever, however, as long as it's not using the MLS with respect to it. You can go to coffee and have a conversation. You do whatever you want with respect to it, but just don't violate the terms of the settlement and don't put it on the MLS. So.
This one says, best way to explain compensation to sellers and buyers. I think we covered that today. At least I hope we covered it. If you have further questions, come up and see me after.
And let's see here. It says number 7. Let me see. And I'm happy to take any more questions, not in this session, but afterwards, if you have questions that I didn't answer, or you didn't understand something I said, or...
So, I'll give you this one. So, the buyer agreement states you get in a certain percentage. The seller is offering less than the percentage. Does the buyer need to pay the difference? According to your contract, yes.
Could you say that again?
Sure. Your buyer agreement says that you're getting paid X. The seller's compensation is Y, which is less. Does the buyer have to pay the difference? The answer by contract is yes. It's up to you and your buyer, whatever you want to do. By contract, yes. But by negotiations, maybe not.
Yeah, that's an example.
You have the right to ask for it.
You have the right in the sales contract, you have the right to ask for the total of X that you're being, is in your buyer broker agreement. And if they don't, this is where we talk about where the buyer's closing costs are going to go up, right? Because they have to make up that difference at closing. So, and that's where a concession could be used potentially with respect to it, to reduce those closing costs.
You read it. Don't read it out loud. Read it first.
I got that. So this is talking about, I guess, the reverse of the scenario where you have somebody that is trying to negotiate in a higher offer of compensation than the seller has authorized. One of the really important pieces is the seller must agree in advance and in writing to any offer of compensation being made to a buyer's broker. So that is a conversation the seller would need to agree ahead of time. Say they get the offer in, then technically you would also need to amend the listing agreement to include that higher offer of buyer broker compensation, if that's what the seller wants to do with respect to this property.
The answer to that is facts.realtor question 80.
Yes, so you'd have to, this is one of the harder parts, is it's not up to everybody, and you can't, listing agents can no longer make sort of unilateral decisions without speaking to their seller, right? They must have those conversations with their seller about what is being offered to a buyer's broker, so.
And so that came up, that was one of Amy's and my questions to Matt, because the question on number 80 in facts.realtor, and if you've not been to this site, they have completely redone it. Completely redone it. And there's all sorts of information there for your buyers, for your sellers. There's everything you can hand out to those people. So go there, and in how you get there is you go to NAR and you're looking for facts.realtor, and it will pull up, and then you click on settlement, facts.realtor, English version, right there. And if you hit print, it'll be about 15 pages.
And it's actually more than that, but it's my favorite resource, because I get asked all sorts of questions all the time, like what about this, what about that, what about this, and 95% of those questions are answered in this FAQ. And so if you are like, it's the weekend, I don't have anybody, I can't call up my broker, or I can't call the attorney, or I can't call Marcy, I'm just kidding, then you can go on NAR Settlement FAQ, and you can actually generally find the answer, and you're like, oh, they have received all of these questions, because it's not just us, it's all over the nation, and they've answered those questions. Like, here's an example. People ask me, what about a virtual showing? What do? I need to have a buyer agreement for a virtual showing. You know what? It's in there, and it says if you're going to do a live virtual showing, you need to have a buyer broker agreement. So they use the words a live virtual showing with respect to it. So it's in there. That's what their guidance is, because lawyers, we write things, and then everybody else is left to figure out what that looks like in practice. This is essentially the way to kind of put a lot of this into practice, is what it means to be boots on the ground at an open house. What can I do? What can't I do? Just tell me what I can do, and we'll do it. That's kind of what this answers. So please take a look at it.
So when we were talking about the seller has to know what you're paying, that's question 80, and Amy and I had lots of questions about that. So we called our attorney friend in NAR and said, wait a minute, it's in the listing agreement. Why do we have to disclose it? We've disclosed it. It's in the listing agreement. And then it occurred to us that what happens when you go to a for sale by owner? You don't have a listing agreement with them, right? So now you have to disclose to the seller what the compensation is that you want to receive from them and get an agreement to that. So if you want to know where that is, that's 1611 in the Code of Ethics. Before you can take a buyer to a for sale by owner, an unlisted property, you must go meet with or talk to that seller prior to going to show the property to determine the compensation, if any, that would be paid by the seller, period. And then you get that in writing, and then you can go show it. If they say no compensation, you put that in writing, and then you can go show it if that's what you want to do. So just be careful of 1611. And in fact, it took us a little while, because we went, wait a minute, it's in the listing agreement. Well, there isn't always a listing agreement. All right. How you doing?
Wonderful.
Did you learn something today?
Yes.
Did we help with that?
Yes.
You're more than welcome. We had fun doing it, didn't we?
We did, and just know it's all going to be okay. It really is. Just pick up the phone, have your conversations. It'll all be just fine. So.
All right. We're here. If you have additional questions, come on up.